All right. Well, good morning, everyone. Welcome to Fair Housing in Action series, Navigating Source of Income Discrimination. My name is Ray Hollingsworth Falu, President-elect of the Hudson Gateway Association of Realtors. The Hudson Gateway Association of Realtors represents 13,000 professional realtors. We empower members to grow their businesses and succeed in their communities, and we are committed to fair housing and extensively educating our members so that they can ethically serve the interests of everyone who needs a home. This is a value that should live in our work on an ongoing basis. At the HGAR, we offer various sessions like this one and CE courses on our HGEDU on a broad spectrum of fair housing topics. I want to take some time to recognize the fantastic work of our Fair Housing Committee and its leadership, our chair, Shanice Williams, and our vice chair, Emran Bouyan. This is a timely discussion for what's happening in our area and in our country today. And maybe something that we're going to talk about today will touch you and help you in what you're doing in your area. So now I would like to send it over to our moderator, Andrew Smith, from our longtime partner, Westchester Residential Opportunities. Andrew, take it away.
Thank you, Bray. Thank you so much, Shanice, as well. Thank you to HGAR and in particular the Fair Housing Committee for co-hosting this with Westchester Residential Opportunities. Again, I'm Andrew Smith. I'm the Deputy Director at WRO. And really pleased to be here. Thanks in particular to Freddie Garcia for all his help in organizing us and keeping us on task. So this is the, as Ray mentioned, our Fair Housing in Action series. It's a two-parter. So this is the first part. And we're going to talk about source of income law and housing discrimination on the basis of lawful source of income. Our second series, our second session will be on May 9th at 11 a.m. I hope you can all join that one. We will be talking then about the practicalities of working with housing vouchers, inspection requirements, landlord incentives, brokers' fees, advantages and disadvantages of working with these programs, and we'll have representatives from the local Section 8 program as well as New York City's City FEPS program to help us talk through and address those questions, as well as Emran, who will be our realtor in that session. So if you have questions throughout this presentation, please feel free to put them in the Q&A box. If you have questions that relate to the May 9th program, meaning they're about administrative requirements with programs and the nitty-gritty working with them, you feel free to drop them in the Q&A, but we won't address them today. We'll hold them for May 9th, and you're going to have to come back to hear the answers. You can register for that May 9th session on HGAR's website or on WRO's website. Whichever you choose goes to the same place. So today's discussion is about what the fair housing laws require in terms of source of income protections, focusing in particular on the New York State law that was enacted in 2019. We have an exceptional panel of experts. I'm so pleased to have each of them with us today to lend their expertise on the topic. So I will, before we dig into the substance, I just wanted to ask each of them to briefly introduce themselves. Carole, can we start with you?
Sure. I'm Carole McCann. I'm the broker owner of Hudson Heritage Realty in Orange County. I'm a director for the Hudson Gateway Association of Realtors, and I'm also a member of Hudson Gateway's faculty.
Thank you. Thank you. Zach, would you go next?
I'm Zach Zeliff. I'm Chief of Staff for State Senator Rachel May, based here in Syracuse and points south and west. Thank you for having me.
That leaves you, Brent.
Sure, thank you. My name is Brent Meltzer. I am the Chief of the Housing Protection Unit at the Office of the New York State Attorney General. And I'll talk a little bit about our unit when I give the presentation later. Yeah, so that's who I am.
Thank you. That's great. Thank you all so much again for being here. And let's dig right in. Zach, I want to start with you from, again, we're looking back 6 years to the implementation of the New York State protections. We had county protections in Westchester and some other places around the state, but we're really focusing on the state law. Broad strokes, what is the law for those who don't know, which might be a few of us? What is the law? Why was it enacted in 2019? What were the intentions of the enactors? And well, let's start there. Thank you.
Yeah, sounds great. So first, I should say, in addition to thank you for having me, my boss and I are typically pretty aligned on most everything, but if you get mad at something that I say, please get mad at me and not at her. And then if you want to follow up and we agree, then you can be mad at both of us, but at least to start, get mad at me. Hopefully we're all in agreement, but yeah, so 2019, actually, so I'll rewind on a personal level. I was working at CNY Fair Housing, the Fair Housing Enforcement Agency, and the equivalent of where Andrew works in many ways in central New York here, in this area of the state. And we were seeing a lot of folks who could not successfully obtain housing with a housing choice, or more commonly known as Section 8 vouchers. And I think a lot of people were seeing this across the state. In the city of Syracuse, they were looking at these sorts of protections. Like you said, Andrew, in Westchester, you had these. And I think there's a lot of research sort of around this time, middle of the 2010s, that was really influential and is still really influential on this topic. I think there was a book published in 2017 called The Color of Law by Richard Rothstein, which sort of is a great history. Always recommended to realtors. My aunt's a realtor. I've been pushing her to read this for a while. I don't know if she has yet, but it's a great book kind of on the history of a lot of American segregation, really, and how a lot of it was based in policy throughout the 20th century that created the communities that we have today. Interestingly enough, Richard Rothstein, he's a historian who actually has a background in education policy, which led him to this book. Kind of, it was sort of the capstone of his career. And it's because he was doing a lot of research on the outcomes of children in education, and found that so much of it was impacted by how our housing developed, the nature of segregation, especially concentrated poverty, where, and this is a broad academic, there's a lot of research into this about how when there is a high level of concentrated poverty, a lot of people working through poverty in the same areas, outcomes are less, school outcomes are less, life expectancy is less. There's a broad range of outcomes which are really unfortunately lower kind of across the board. And it's a huge fair housing issue, in the fair housing industry. A lot of folks are really focused on this. So there's a few ways, policy-wise to kind of combat this, but there's the work, and I'll post this in the chat. There was one economist who is sort of, there's many people working on this, but there's one economist named Raj Chetty, who is associated with a project called Opportunity Insights, which is based at Harvard, and did a lot of really great research on sort of how outcomes when families have social mobility, the choice to live where they want, it really affects outcomes of kids, education opportunities, again, lifespans, lifetime outcomes, all sorts of really interesting work. They did a lot of interesting work where they gave people sort of counseling on the opportunity to live where they wanted to, people who had Section 8 housing choice vouchers or other similar types of subsidies. And I think there was a lot of preconceptions before that people lived in the same areas because of choice. But when you allow people to have more choice, there's a wide range of people who make all different sorts of choices. So that's, I don't know if I can speak to kind of the broader whole legislature, but in our office, my boss has a very strong familial background in fighting segregation, and it's been a big part of her career. And this is why we were so passionate about this. And one of the main reasons, I think, why she ran was that this was stuck in the legislature up until 2019. That was our first year in office, and it passed in the budget, which is I think Brent's going to go over the details a little bit later of exactly what the law is. But really looking at these sorts of outcomes, and not just outcomes, but sort of thinking about freedom. You know, freedom conceptually, something we think about a lot, is very important in giving people the opportunity to live where they want. Like, right, they have the Section 8 housing choice, whatever subsidy they have, and they are able to pay the rent. They should have the freedom to live where they want to and have choice. Choice is important. So I think that was kind of the background of why, you know, at least from our office's perspective, probably across supporters as well. Can't super speak for that, but of why we were looking at passing this in 2019 and why it was successful. Later on, I'll go over sort of next steps in enabling people to sort of have maximum freedom of choice. But I'll post a lot of this in the chat if folks are interested, and also happy to send folks to other resources if folks are interested in digging in more.
Thank you. Thank you so much. That's great. And obviously, you know, I will get into a little bit of the details of how the law works, but the lawful source of income protections are extremely broad. They really apply to any lawful source of income. So no, you know, I know no drugs, prostitution, or guns or whatever, but I mean, pretty much anything else is protected, and that's intentional in the law. But like as you said, Zach, I think the law was enacted to some significant degree to protect these vouchering programs and to ensure that people who have these voucher programs, which is like what, 2.3 million households in the United States or some crazy statistic like that, that they have the freedom of choice where to live anywhere they can afford. And obviously affording, you know, afford is a limitation in and of itself, but yeah, that's great grounding. Thank you. So Carole, you're on the ground. You're a realtor, broker, owner. Could we get your insights into how this landscape has changed for the realtor community over the past, you know, 6 years and beyond, you know, 6 to 10 years or whatever, in the wake of the law changing six years ago?
Sure. And I think I have to start with the landlord perception of vouchers. And over time, you know, voucher systems have been enforced since 1974. So even before I got into real estate, which was 1986. And over time, the voucher system has gotten a really bad reputation because of landlords who had unfortunate experiences with some of those tenants. So they were very hesitant to accept vouchers for those reasons. You know, they were afraid they were not going to get their rent, their properties would be damaged. And you know, if they weren't getting their rent, how would they then have that, you know, make that tenant move out? They'd have to go through all kinds of shenanigans to get somebody out. So on top of that, they also had to have their properties inspected, and they weren't so happy about that. So that's the way it's been the entire time I've been in real estate. And unfortunately, even though we had this law passed in 2019, there are a whole lot of people who have not gotten the memo.
Yeah.
So, you know, we still have landlords who want to refuse anybody with a voucher for all the reasons that I mentioned. And unfortunately, we still have a lot of realtors who don't really understand the process and what their requirements are under this law.
Right. And we'll, you know, we will talk a lot on May 9th about the process and some of these administrative issues. So thanks for referencing that. I mean, staying with you, Carole, for just a minute. So what, you know, when you're out there working every day and interacting with other realtors as well as landlords, just frame for us kind of what does, in your experience, what does this discrimination look like? How are landlords and realtors reacting dealing with folks who have a voucher, whether it's Section 8 or some other varietal.
We still have landlords who are refusing to accept vouchers. Even when realtors are educating them and explaining them to what the laws are at this point in time. And there are just some people whose minds you can't open. We also, we have realtors who are a little bit hesitant to explain to a landlord what the deal is now. There are many consumers who are receiving assistance who have no idea of what the law is. So there's a lot of education going on from the realtor side to both landlords and consumers regarding source of income.
Fair enough. Thank you. And speaking for, for Westchester residential opportunities, source of income, investigations, testing, we run a testing program, as most of you know, investigations and enforcement on source of income issues are definitely a top priority for our fair housing team. That's in part for all the reasons that we've already mentioned, the importance of the vouchering programs that they play in our community and housing some of our most vulnerable and low income neighbors. And it's also because, like you said, Carole, discrimination against voucher holders in the market. For those folks who recognize it, is one of the top 2 complaints that we receive from the community and from realtors every year. So sort of a source of income and disability related issues are the top 2 issues that we, over the last 5 years or so, every year, they'll be the top 2. Brent, turning to your office and the Attorney General's office writ large. I mean, my sense is that this is a top enforcement priority for the Housing Protection Unit. And I wanted to, to turn the dais over to you for a moment to just explain, help us understand the law, but also understand, why it's a priority, what that means, what enforcement looks like, what kind of cases you're looking at, and what kind of remedies you're looking for, how you're trying to use those enforcement tools.
Yeah, and I can go into a lot of what we're doing, but I'll probably start with the law because I think it's important for people to get the law. But it is a priority for our office. It's a very, very large priority for our office, and it's not just my unit. You'll see within my slide, my unit's pretty small, but we also have a civil rights bureau, and we have regional offices who all work on these issues. And at the end of my slides, you'll see we have a couple settlements. One, Andrew, that we did. Not collectively together, but we partnered together at least partly on that. And so, it's a really important issue, and we think it's really, really it's important that people are not violating the law. Carole, you mentioned a couple of the reasons people don't want to do it. I mean, I think realistically, and I always try to be like honest about everything that I do in my life. One of the things is that the programs can be a little burdensome at times, right? And I mean, that's why you're having the next session is to get people to understand how to navigate that. And so it is true they're burdensome. Unfortunately, it's the law, right? And so like whether it's burdensome or not, it's the law, and that's when I come in. And so you don't want to see me because we end up prosecuting these cases and going after people. So I'll talk a little bit more about like what we're doing in that space, but maybe we can start with the law. So I have a slide presentation because I need to have that. So
visual aids, always.
Yes, always good. All right, hopefully people can see that. Is that right?
It is. I don't see it yet. Yeah, there it goes. Popped up.
There it goes. Okay. Now, and I'm not, I will say I'm not super proficient with this, but I think I got it. All right. So there, everyone can see that. Let me put that down there. So again, just talking about my unit, we started in August of 2019. The office was doing landlord-tenant related investigations before that time, but we didn't have a dedicated unit. I've been here since 2016, actually. And And so I used to joke that I ran a bureau. If you deal with co-ops and condos and those big thick packets, I ran that bureau. But then my night job was to investigate landlords and brokers and other people who are violating the law. Now I get to do it full time since 2019. We do focus in primarily on tenant issues and also just affordable housing issues. That's where I come from. That's my background. We're a small but mighty unit. There's only 4 attorneys in the unit. But like I said, we do partner with our Consumer Frauds Bureau, our Civil Rights Bureau, our regional offices. And the majority of our work is affirmative litigation. That's why I love my job, is I actually have subpoena power before going to court. So I can issue subpoenas to have people give me documents and sit down under oath for testimony. So it's quite powerful, which is again why you don't want to violate the law and have me show up, because it's not fun to have to turn over all your emails and have to sit and answer all the questions that I ask of folks. We do also provide educational materials for the public. We have documents on unlawful evictions, right to organize, other stuff. Again, very tenant focused. So I will confess that I stole some of these slides from colleagues in my office, and I actually didn't know this, but New York had the first civil rights law in the United States. I was actually quite shocked by that. Back then, it was prohibited people from discriminating based on race, creed, color, and national origin, right? So it wasn't a lot of, the characteristics, as I guess we'll go to the next slide, really have expanded over that time. In 2019, as was discussed previously, the legislator included source of income as a protective characteristic. And so what I wanted to really highlight, and again, I'll talk later about some of the work we've been doing with some behavioral scientists, but I really want people to, when they're thinking about this, that when you discriminate based on source of income, you're actually, sorry, I have something in front of you. It's considered the same as any other type of discrimination. And so, in your mind, hopefully not, but in some people's minds, I think they think, well, it's not the same, it's not the difference, but under the law it is. So by saying I don't take Section 8 is the equivalent of saying I don't take, Black tenants, or I don't take female tenants, or I don't take gay tenants. And so, it's really important to understand that morally you are saying the exact same thing, that we as a society, we as a legislature have determined that source of income is discriminated and needs to be protected just the same as any other of the characteristics that are found in the human rights law. Let's see, go to the next one. Wait, yeah, okay, I got there. All right, so what counts as lawful source of income? So the definition in there is federal, state, or local housing assistance, including Section 8, or any other type of voucher or any other form of housing assistance, regardless of whether it is paid to the tenant or the landlord. So what does that mean, right? So that could be, public assistance. So if someone's getting public assistance, you can't discriminate against them. Social Security benefits, child support, alimony or spousal maintenance, foster care, or any other form of lawful income. So a lot of times you'll hear people talk about Section 8. And that's what a lot of the discrimination is, but it's not the only thing. We've certainly had people say, well, I don't want someone who's on Social Security because it's not a lot of money. I mean, now the amounts is not the issue, it's the source, right? So just to be very clear, that is the sort of difference. Now, Andrew and Freddie, I'm not monitoring the chat. So if there's any questions along the way that you think I should stop and answer, please stop me.
Will do.
All right, so that's what counts as lawful source of income. So, so then, who's covered by this? Who actually has to follow the law? And so it's any housing provider and people who sell, rent, or lease housing. So it's obviously the simplest one is landlords, right? Now, there's a carve out if you're a landlord in an owner-occupied 1 or 2 family home. So if I'm the landlord, I live there, and it's a 1 or 2 family home, this law would not apply to you. Still shouldn't discriminate, but you wouldn't be violating the law. Real estate salespersons and brokers, managing agents, owners, agent and employees of the above, co-op boards and condo associations, and also subletters. So, right, if you have a subletter and they put a sign on a listing on Zillow saying no Section 8, that's a violation of the law. If you're not aware of it, you're probably okay. But if you knew about it and condone it, then you may have some problems. All right. Who must follow the law? Well, again, it has to be anyone who's covered by that. So it's anyone who sells, rents, or leases housing must follow the human rights law. So now, I'm just trying, I don't want to give any counterfactuals, but I was trying to come up with a place where you're saying I don't like Section 8, but it wouldn't, if you're at the bar and you're having a drink with someone and you say, I just don't really like Section 8, that's not going to violate the law. Now, if you're a landlord and you're at the bar and saying, I'm not going to rent anyone for Section 8, and you actually do that, that would violate the law. So what acts are prohibited? So, again, refusing to rent, sell, or lease, right? I don't take Section 8. Steering renters and others to certain neighborhoods. So like I have 5 buildings, and I'm going to take the Section 8 voucher holders and put them in 3 buildings and not in the other 2 buildings. Similarly, as a broker, if you steer them to some landlords and not other landlords, that could also be a violation. Oh, geez, I did not update this. So never mind. Some of these are not relevant to Section 8. I apologize. Treating you less well than others. And we'll talk a little bit later about terms and conditions. But, you can't, give certain perks to people without vouchers than people who do have vouchers. Denying equal terms and conditions, which I'll talk a little bit later. Harassing you, so you can't let them come in and then harass them. And then obviously statements of discrimination, such as no vouchers. So when you're in the field and when you're thinking about this, you want to be very careful, because the way the law was constructed is to give it the broadest and most protective reading as you can, right? So what they said, the legal term is liberally construed for the accomplishment of their remedial purpose, which is to stop discrimination. So when you're thinking about, well, is this close? Is this in the gray area? If it's in a gray area, you may want to step away, because the courts are going to consider gray areas as much as possible to protect folks with the characteristics, which in this case is source of income, lawful source of income. The reason I had that slide is because I want to talk a little about terms and conditions, right? Because this is a lot of the times where we can see discrimination happen. So, right, Andrew had asked Carole about forms of discrimination, right? There's obviously the flat out, I don't take vouchers. I talked about steering, where you send them to other places, but we see other instances where people ghost folks, right? So I'm talking with a broker and it's going great. I'm going to have this apartment. I mentioned that my source of income is Section 8. And then the broker says, all right, well, give me a call back later and we'll set up a time for you to view the apartment. And you don't answer the phone. You don't talk to them anymore. You just basically stop speaking with them. That would be a form of discrimination if you're not doing that to other people. So, but in other situations, landlords we've seen use certain tools, if you will, to try to circumvent this. And so instead of saying, I don't discriminate, they come up with other terms and conditions that either are not applied equally, or in certain circumstances with Section 8 are not applicable, and so therefore are discriminatory. So an example of that would be an income test. So I'm based in New York City, and we do have some landlords that say, well, you need to have 40 times the rent in income. Now, if your entire rent is covered by the government with your Section 8 voucher, then there's really no reason to have an income test. And it can be, and no voucher holder is going to be able to meet that test. And so therefore, it's discriminatory. Even if a portion of the tenant's rent is covered by the government, and then a portion is covered by the tenant, still can be discriminatory depending on how it's applied and what you're doing with it. And so unfortunately, I can't give legal advice, so I'm not going to get into the nuances of that. And you should speak with an attorney if you have any questions. But you should be aware that income tests can be discriminatory. Similarly, requiring a guarantor. When someone has a Section 8 and the entire portion of the rent is paid by Section 8, why do you need a guarantor? There is no basis for that, because the government is essentially being the guarantor on the rent there. Requiring prepayment of rent can be discriminatory. Section 8 voucher holders can't prepay rent. That's not how the program works. And so therefore, requiring a prepayment can also be discriminatory. And again, purposely failing housing quality standards. So like you destroy something in the apartment so that it fails, or otherwise failing to comply with Section 8 requirements, right? I'm not going to sign this document. I'm not going to do this, can also be discriminatory. Another thing that I think is actually unique to Westchester and a few other places in the state is when there's more than one voucher distributor, like a public housing administrator. And so you say, well, I'll take the Westchester Section 8 voucher, but I won't take the Yonkers voucher, for instance. I made those up. But that can also be discriminatory. And so you can't just pick and choose, right? That's the same as saying, well, I'll take employment income, but I'm not going to take unemployment income. It's the exact same thing. It's discriminatory in the source of income. And so, Andrew, maybe I'll circle back to you about like how we want to talk about like what we're actually doing. But I just want to give a couple examples in your region of cases that my office has done. We are actively taking complaints and monitoring listings and making sure that no one is discriminating. So we settled, we call it the Platzner settlement, which was, it was interesting. We had an investigation, and WRO had an investigation, and we then we didn't fully join forces, but we were obviously speaking with each other about it. And we collectively obtained 20 apartments to being rented to people with vouchers. So basically, Platzner agreed that they would have to take at least 20 people and rent out 20 apartments to people with vouchers within a certain amount of time. $105,000 was paid to WRO and the OAG. We also settled with a broker, Marciano, and Century 21 Settlement is a broker who also owned properties. So we collectively obtained 9 apartments being rented to people with vouchers. We got the brokers to waive any broker fees for any applicant with a government subsidy for a period of time, and $40,000 was paid to our office. And then finally, this was in New York City, we settled with Shamco, which is quite possibly the best named landlord ever. We obtained $400,000 in restitution for nearly 500 prospective tenants that were discriminated against, and nearly 60 apartments are being rented to people with vouchers. And again, in all these settlements, we also get other relief, trainings, making sure that we call it injunctive relief, so that they can't discriminate into the future. And so on top of the 20 apartments, the 60 apartments that they have to rent to folks, they also just have to, when someone appears and says, I have a voucher, they can't discriminate, and also have to rent to them on top of the numbers that we've requested.
Right, policy changes
Exactly.
and things like that.
Yeah.
And I love this stuff, Brent. I mean, I think everyone argues about what the right remedies are for discrimination in any context, and that's the controversial topic. But what I really love about these settlements is opening units up to voucher holders, specifically reducing barriers to entry, whether that's a broker's fee or something else, and basically compensating for the non-compliance, if you will, or making up for the damage that's been done in an affirmative way that really helps voucher holders.
And I should mention, because there's a lot of brokers on here, Andrew, we also are partnering with the Department of State, who also have bring enforcement actions. Obviously, there's a division of human rights at the state level, but DOS has brought actions where they've sought fines and both suspensions and revocation of brokers' licenses.
Of licensure,
So
right.
so for this as well. So like it's serious, and people are taking it seriously. My understanding is the governor now is has taken it seriously and has put some more resources into that at DHR and DHCR. So it's important. It's like important that people understand what the law is and comply with the law. And if they have problems with, like, again, with administrative burdens or other stuff, that's not an excuse. You may want to talk with the PHAs and work with Zach and your legislatures to make sure that the programs are more efficient. Because, like, at the end of the day, it's actually a good thing. It's a guaranteed source of income. Like it's like I'm employed right now, but I could be fired tomorrow. Where the Section 8 voucher, I mean, I guess these days things are a little up in the air, but at the federal government, but practically speaking, it's money that's going to continue to flow, whether the tenant is employed or not. And in fact, if the tenant becomes unemployed, the government pays more on it. So it's a, there's a lot of, there are some downsides, but there are a lot of benefits to it too.
And I think, Carole, you might have a perspective on this, but I think the pandemic and all the loss of income that a lot of households experienced may, and you know, a rash of evictions and eviction protections may have changed some landlords' perspective on these sort of government programs that guarantee rent every month. Maybe not enough that we don't need to have a panel discussion like this, obviously, but it's true even when somebody loses a job or otherwise Section 8 continues to pay.
Yes. And interestingly, most landlords across the board were not aware that, you know, by and large, the rent gets paid to them. So it is basically a guaranteed source of income for them. And once you're able to educate them a little bit, their perspective does change.
Yeah, that's great. All right. So, and one thing I wanted to, Brent, thank you so much for kind of like running through the law, because I think that's super helpful for everyone. One thing you said in passing, I just wanted to clarify is, so the protection is around the type of where the dollars come from. It's not about how many dollars there are. So, I mean, ultimately, the source of the income is protected, but a landlord or a realtor is allowed to care about, you know, the amount and whether that's documented, right? So you can still require, you know, a satisfactory evidence of what that income is, that it's sustainable in some way, just like you would for anyone else. Again, anyone with a job can lose their job tomorrow, accepting that that's the case. So the protection is about where the money comes from, but not, you know,
Right.
you're still allowed to check out this, document the source and know the amount.
Yeah, I mean, the tenant that comes in has to be able to pay the rent. And again, like, I think a voucher can pay that. You know, one thing, and I apologize, I'm law enforcement. So I know there's probably like 95% everyone following the law, but I always deal with the 5%. And which is, you know, a little bit to Carole's point about you have one bad experience with a Section 8 voucher holder, all of a sudden you taint all of them. And that's not really fair. It's similar, like if you had, you know, with race or gender or family, not everyone, that's the whole point of protecting these folks, is that just because you have one bad experience with one person doesn't mean everyone else is bad. But to my point, we also do see sometimes where landlords will people will set the rents just above what Section 8 will pay. But then when someone who doesn't have Section 8 come in, all of a sudden the rents get lowered, right? So like that sort of thing we catch all the time. And so like, just don't, you know, remember, just don't play in the gray areas.
Yeah, thank you. Yeah, that's great. And I did see a question about co-ops, and I wanted to just clarify one point, because for us, the folks based in Westchester, there is some confusion still out there. So Westchester used to have a source of income law that had a number of exceptions built into it. One of which was for units below 6, I think it was 6 and below. The other one that came up all the time was co-ops. Basically, it had an exception for co-ops. The law didn't apply to co-ops. I don't know why, but I wasn't in the legislature. None of those apply to the state law. Those exceptions do not exist. Brent went through the only exceptions that apply. They're the same that apply for race or national origin or anything else. And in fact, Westchester County, again, we're talking about the state law principally, but Westchester County's law has now been amended in middle of 23, I think, to basically conform to the state law. So none of those exceptions exist anymore for co-ops or smaller, you know, six and lower units, anything like that. Okay, I think we're getting a lot of questions about income tests, about background checks, about credit checks, what's allowed, what isn't. And that is timely because that is the next thing that we want to talk about. And Brent kind of teed this up very well in talking about what, some of the types of discrimination that are out there. One of which, like these income tests. I want to talk about things like income tests, credit scoring requirements, in the context of what I call proxy discrimination. I mean, which is, is really just a term for having a bunch of rules, or a rule, whatever, having a rule that indirectly does what you are not allowed to directly do. So if you, and this is the case across fair housing law generally, it's called disparate impact in some cases. It's, basically if you have a facially neutral rule or policy that as implemented would have a disproportionately adverse effect on someone of a protected class, that is discriminatory, even if the intent to discriminate cannot be proven. So getting into this question of income requirements in particular, because I think that's an area where we have litigation outstanding, and a lot of the organizations like WRO that do this work around the state have investigations and enforcement actions pending. There's a lot of confusion out there, and I think the questions that are popping up reflects that. I just read, I don't know, probably a lot of the folks on the Zoom get the NYSAR, what's it called? The New York State Realtor magazine. I was looking at the April edition, and the legal team at NYSAR writes about this issue, and they said, to paraphrase it, a minimum income requirement is generally legally compliant if voucher applicants such as Section 8 are exempted from this requirement. So if you read the Division of Human Rights put out a 2020 guidance document, which was great, like, a year or so after the law changed, and they say something a little different. They say a housing provider cannot have a facially neutral income or wealth requirement that is equally applied, but has the effect of excluding populations with rental subsidies. And they give it as an example of that, that an income requirement of a multiple of the rent would be unreasonable if applied to a tenant who has 70 to 100% of the rent paid by a vouchering agency. Those are two different interpretations of the law. Zach, who's right? Who's wrong? What is the law on this topic? What's the issue? Why is this a hot button topic? Why are we talking about it? How can we fix it?
Yeah. So Freddie, can you share the picture thing that I provided? So this is something I found on Reddit, our landlord, I think last year, talking about someone in New York who I believe was being sued. The original post was someone who was being sued because they said, you don't accept Section 8. They were unaware that was the case. As Brent said in his talk, this is another Kilo Foxtrot 4. This user is another landlord informing the original landlord, saying it's the equivalent of saying no blacks allowed, that you didn't take Section 8. But then he goes on to say, they go on to say, you're always safe sticking to income criteria that Section 8 people can't meet. That way you're discriminating, but not discriminating. And then down the second post, I don't know if you can scroll down, Freddie, but it says, it's pretty easy to knock out 99% of Section 8 people with income or FICO requirements. You just can't blatantly say, I don't do Section 8, is what he says. So this is what we're seeing. I think I've been using this with an example of some bills. I think a lot of the, like, what isn't legal is kind of currently being litigated of how that fits in with the law. And I think Brent could probably talk more to that. I think things that are facially kind of ridiculous, the 40 times income rule, that That's pretty facially ridiculous. As Brent said, there's a lot of gray areas. So, what isn't allowed as a standard, it's kind of situation specific. And I think I'm not an attorney. I'll let Brent speak to that more. Also, none of us can give legal advice, but I will say we have a bill that, we're seeing this and we feel like it frustrates the intent and purpose of the law, right? A lot of these things, income and credit. Now, income is a little bit simpler in terms of a legislative perspective, we think. Here is in the chat is our current proposal of sort of clarifying this. There's two sets of rules, one sort of for subsidy or voucher recipients that the rent is guaranteed by the government. So that's your housing choice voucher. I think City FEPS in New York City is the same way. There's a variety of, there's vouchers for people who in New York State who have HIV or HIV positive. There's a number of these sort of categories and it sort of sets the rules for those. And then there's also a sort of different category, and what we see here in Onondaga County is people who don't have vouchers, but who receive subsidy kind of cash allowance for people who have cash assistance from the local Department of Social Services. And it just kind of clarifies that if they are getting that income, there can still be a income test for 1/3 of that share of the rent, right? So not the overall rent, but let's say, I think it's comically low in Onondaga County. That's another issue which should be raised. I think it's in the vicinity of $550. Say a rent was $1,000. You could take the $450. You could require 3 times that income, but not the $550. So it's kind of clarifying those best practices. And that's how, just to be clear, this is a bill. We are working to pass this. This is not a law yet, but it's kind of that next step we view of sort of protecting the original source of the law. This bill originally included credit. It's a little bit more of a complicated issue. I think a lot of it's still being litigated. We hope to sort of return with another bill. So if people want to get in touch with our office and sort of talk about, there's a lot of legitimate business interest in doing that credit. I saw a lot of stuff in the chat, from the realtor perspective about using credit, especially in sort of the second situation where it's public assistance that isn't fully guaranteed by the government. So we kind of thought we would work on this first, and then we're going to work on that sort of in the off session of the legislature, which is coming up soon, and then try to work on that in future sessions. So I'll say that's kind of what our office, and we're working with a lot of the fair housing enforcement world. CNY Fair Housing, where I used to work, has been a strong partner, where we talk to a number of fair housing attorneys who are in court and see this stuff all the time. If you want to weigh in, we are more than happy to talk to anyone on it, and you can contact our office.
Thank you, Zach. And obviously, this is an area of the law that needs clarification. It's super important, as folks, whether Brent's office or folks like CNY or WRO who are out there investigating this stuff. It is an issue that is popping up all the time, and the law is not crystal clear on it. So it needs clarification, I think, for the benefit of everyone, of landlords and realtors, as well as the people who are out there investigating.
Andrew, I'd say 2 things to that, though. One is that, to my earlier point, if it's a gray area, just don't do it, because again, the courts are going to liberally construe it. So I saw some comments to my answers to questions saying, "Can you give me clarity?" Is like, well, I can't, because it is a complicated, but if I'm not your attorney, I'm not giving you any legal advice. But if I were giving someone legal advice, I'd say if it's a question, just don't do it. California, interestingly, does have that language. And Zach, if you ever want me to give you that language, I can happily.
We're gonna connect after,
and I'm happy to give you some of that language. That's out.
All right. Yeah, thank you. And I'm seeing we got a lot of great questions. I really appreciate everyone's engagement on this stuff. Someone asked, can landlords refuse Section 8 if their reason is that they do not want to deal with paperwork, inspections, etc.? As Brent said, no way. You can take that up with the PHA and say, make this easier, please, or take it up with Zach and see if the legislature can help. But you can't say no because you don't want to deal with the paperwork. That's crystal clear. So thank you for that. I wanted to, I don't know if others have perspective on credit scoring. It's a topic that we talk about in every fair housing presentation that we do because it is an area. So yes, in most cases, a landlord or a housing provider is free to run a credit check on a prospective tenant. The exception being where the voucher would cover 100%, where you can go run credit on HCR or on the Department of HUD if you want, but the individual is not paying your rent, so it's not relevant. I think as Zach said, there's a legitimate business interest in determining whether a tenant is a good prospect to pay the rent or their portion of the rent, if it's significant enough. And our perspective on that is that is legitimate, but credit score might not be the right way to do it. Meaning, credit scoring is a flawed and it's self-discriminatory system with a lot of problems when used in this context. It's pretty good, I guess, at determining whether you should give someone a credit card or consumer debt. It's somewhat predictive in that area, and it's not very predictive when it gets to whether someone's going to pay their rent. There's a lot of people who pay their rent before their credit card bill because they don't want to be evicted. And there's a lot of sort of built-in, like I said, bias in the FICO kind of credit scoring system, whether that's against young people. Like my kids are all young adults who have bad credit because they have no credit. They haven't been out there, paying student loans for 10, 20 years or establishing a good credit history. Folks who just come into the country who are unbanked or who use alternate kind of credit or banking system like SUSUs or paycheck kind of lenders, they're not going to have good credit scores either. And a lot of those folks are going to fall into protected classes. So that's my kind of soapbox moment on credit scoring. I think it's a kind of a broken. It may be the best system that we have for now, but it's definitely not a good system in terms of, from the perspective of determining if someone's likely to pay their rent. All right. With that, Zach, thanks so much for this discussion and for taking the issue up. I mean, I really appreciate your leadership and the center's leadership on this issue. Carole, wanted to turn back to you to talk about, well, let's start with roles and responsibilities. So a lot of our, we've got a really mixed audience of different folks from different backgrounds, which I really appreciate, but I know we have a lot of realtors on the line. What's the responsibility of what's the role and responsibility of real estate brokers and agents in dealing with source of income discrimination, whether that's by other agents, by other landlords? What do we want to see from your brethren and sisterin out there in the market on this issue?
Well, our responsibility is education first and foremost. We do have direction from the state where we do have to provide an anti-discrimination disclosure to anybody that we meet and speak to regarding real estate, whether it's rentals or otherwise, and a fair housing notice that we're required to post pretty much every place, and also give a copy of that to consumers, landlords, tenants, letting them know what their rights are, and if they feel they've been discriminated against, what steps they can take to file a complaint. So that really encompasses, all our job, all of our responsibilities. as well as trying to open the minds of folks who really don't understand what the law requires nowadays. So that goes back to that education and information.
Thank you. I appreciate that. And are there, just building on that, are there particular best practices that you would recommend to agents or landlords to avoid discriminating source of income generally, but maybe just generally?
Well, and I'm trying to keep my answers from falling over into the May 9th session.
Yeah.
You know, so I'm a little bit limited here, but really it does go back to that education of informing landlords what the law is, recommending to them, if possible, to have their properties inspected. You know, especially if they own several rental units, see if you can have your properties inspected prior to tenants coming to apply for them, and that will save everybody a whole lot of time. Letting tenants know that these laws are here to protect them. I will tell you, 99 out of 100 tenants who call just my office, and I'm one little tiny office in you know, many, almost every single one asked if our landlords will accept Section 8. So that education needs to get out there. So that's that really best practice thing. And I could go into, you know, if you're talking to a tenant, you want to request a copy of the voucher, but that really is all for the May 9th section.
Okay, good. Thank you. And I appreciate you deferring to May 9th, and we will go into a lot of that stuff and how to, you know, just demystifying in part, just, you know, what those requirements are, how to deal with them, the inspections, you know, what the inspections are actually looking for and why, and hopefully making, you know, reducing the perceived burden that some landlords have. All right, awesome. What I wanted to touch on next, and maybe Brent, maybe this is sort of between you and I could sort of close this one out, is just what a complainant should do. And I guess I would say more broadly, you know, so if you want to file a complaint, whether you're a voucher holder or someone who feels they've been discriminated, or anyone else who feels that they've been discriminated against, how do you go about doing that? So maybe we'll start with Brent. We'll start with you, and then I'll chime in.
Yeah, so you can go to our website. That's probably the easiest and simplest way to do it, ag.ny.gov. And we have a section that says complaints, and then we actually have a source of income discrimination complaint form. So it's pretty basic, straightforward, comes to us. Now, the thing is, we're not the main enforcer of this law in the state, at least for individual complainants. That's the Division of Human Rights. So you can also go to their website and file there. But we do want to know about this because we are doing more systematic enforcement and looking at broader trends and looking for people who are discriminating and brokers who are discriminating across the board. So so we do want to have those complaints come to us. We sometimes send cease and desist letters, and like I said, open up investigations with subpoenas and taking testimony.
Awesome, thank you. For folks who, for folks who have experienced alleged discrimination in Westchester County in particular, there's also the Westchester County Human Rights Commission, which functions similar to the Division of Human Rights in that they will receive a complaint, investigate it. They have hearings and a whole agency process to investigate. The other folks you can call, or you can call WRO and talk to us about it. We're happy to help you figure out where to file a complaint, whether to file a complaint. In some cases, we will do our own investigation to try and substantiate whether or not the housing provider is discriminating and do something about it ourselves. So We're always happy to talk to folks. We're always happy to talk to realtors. I probably speak to a realtor once a week with a question on fair housing laws, and we're always happy to do that and trying to help people do the right thing. As we've gone through some of these issues today and just seeing the questions that are all popping up, this isn't all easy. It's not all easy stuff, but it's the law. So we gotta do the right thing. I think Brent's advice is great. If it's gray, just don't do it. I love that. But if you're stuck on an issue and not really sure what the right answer is, you all can always feel free to call any of the folks here at WRO. Our phone numbers are all listed on our website, wroinc.org. And this is what we talk about all day long. So we're happy to do it. I wanted to remind folks about, again, the May 9th session, which starts at 11 a.m. And we'll hear from a bunch of the folks at CVR who run the Section 8 program. We'll hear from folks who run the mobility program in Westchester County, which is a really exciting program. And we'll also hear from the folks who administer city FEPs, which is more and more becoming an issue in Westchester over the past couple of years as those vouchers have come up. The process is a little different. We want to make sure we can work through all these questions about inspections and other, administrative requirements there. All right, so Freddie, I wanted to, in the couple more minutes we have left before we let people go about their day, just to look through the Q&A and see if we can direct folks. One question is there a phone number for general fair housing inquiries at WRO? That number is 914-428-4507. That's 428-4507. Just ask for anyone in the fair housing department. Thank you, Sandra. Okay. Let's see.
If you want, Andrew, I can go through them and read them, and then you can, folks can jump in if you have any.
Yeah, I'm just trying to look through. I mean, some of them we've really already talked about. So there's a question in here about how the law works, the exception for a two-family owner-occupied home. So what's allowed, what's not allowed? Is it anything goes? How is a realtor to deal with that situation, which is a question we've gotten several times. I don't know, Brent, do you want to tackle that one?
Sorry, what was it again? I lost the last part of it. Yeah.
So it's the first question is what is the exception in the law, what we call the Mrs. Murphy's exception for a two-family owner-occupied home?
Right.
And then bigger question is, and what does that really mean when you take into account one, the 1866 law and the role of a broker in a transaction?
Right. Well, I mean, I don't know how many brokers would do that. The easy answer is that if it's owner occupied, right? So the owner lives in the building and it's a 1 or 2 unit building, the law doesn't apply. So if it's a 3-unit building and the owner lives there, it applies. If it's a 1-unit building or 2-unit building and the owner doesn't live there, the law applies. So I'm not sure I understand the second part about it with the brokers. Yeah. Brokers. Yeah. Sorry, Andrew.
No, it's totally fair. It's probably my own, I'm not expressing myself well because I've had this conversation in shorthand in my head. So there's 2 things that I usually tell agents when this comes up. And the first is that while this is an exception to the New York State human rights law provisions for an owner-occupied 2-family home, there are no exceptions to the 1866 Civil Rights law, which addresses basically race, national origin, maybe religion. So nobody is ever allowed to discriminate on the basis of race even if they are renting out a room in their home. And the other thing I would just add to it is that a lot of times this comes up. I get a call from a real estate agent saying, "Hey, I have this situation. I'm representing Mrs. Murphy who wants to rent out her the other apartment in her two-family home, and she doesn't want to rent to blank. What do I do?" And I say, well, sounds like Mrs. Murphy has this exception under the law. She might be okay being a bigot, right? But you aren't. You, the real estate agent, are going to get in trouble. You don't want to be anywhere near that. Ethically and just reputationally, it looks horrible, but it's also, you don't get the benefit of this exception. Only she does. So that's when you're in a very awkward situation, because you have to advise your client that if that's the way she wants to play, that you can't represent her. And that's the right answer. Okay. What about registered sex offenders? I'm not sure what about registered sex offenders is the question, but if you're asking, do you have to rent to a registered sex offender? Yeah, you're allowed to do criminal background checks on tenants, whether they have a voucher or not, as long as you do it for everybody, whether they have a voucher or not. So the voucher is not relevant to that inquiry. Criminal background is a whole nother topic, a whole nother panel discussion that maybe we should have.
Yeah, I'm not expert on this at all, but I do know in New York City, there was just recently a law passed that limits a little bit of what you can look at on criminal background checks. Again, not expert. I know this is not New York City, but it's possible some folks are also doing work in New York City as well as Westchester. So I wanted to mention that.
Yeah, thank you. Thank you so much.
Mm-hmm.
And, we always, we recommend to landlords that every one of them should have a criminal history policy. If they're going to screen for criminal history, they should have a policy, work it out with an attorney, make sure it complies with New York State law. New York State law has a bunch of restrictions on, you're not allowed to look at arrests, for example. You can look at convictions. HUD has a 2016 guidance that I think is really helpful in thinking through how to put that policy together, because they want you to look at on a case-by-case basis at the conviction history that pops up, but have policies that look at the recency, severity, and nature of the crime involved, and take into account rehabilitation. It's quite a complicated inquiry. Why is this such a big topic? Because our criminal justice system is a mess, right? It in terms of conviction, sentencing, across probation, across the board, it disproportionately impacts on Black and brown people. So it is, if you're screening for criminal history, you may indirectly be discriminating against those groups, whether that's your intention or not.
Along the lines of screening, there's also Real Property Law 227F, which I put in one of the answers to one of the questions, which is informally called the blacklisting law. And so landlords and brokers are not allowed to use tenant screening reports that include landlord-tenant records, or otherwise can't use landlord-tenant records to deny anybody. So you can use them, you just can't use them to deny anybody. So really, effectively, you can't. You shouldn't be using them. So you can get them. There's a presumption that if you get them and then deny somebody, that it was based on that. And so you're not allowed to deny someone based on their landlord-tenant record history. And that's a statewide law that we investigate and do prosecute. So people should be aware of that.
And Brent, does that include like eviction history? Or
yes, 100%. That's what it's meaning. Yeah. I think part of it is that because a lot of times you don't know what's going on in housing court. A tenant may be withholding rent because of repairs in the building, or the landlord brought an eviction proceeding because they're a bigot. I mean, there's lots of different reasons, and so the legislature basically said you can't use landlord-tenant records to deny an applicant for housing.
Thank you. That's great. Really interesting. I did not know that.
Yep.
We have a lot, obviously the state, well, Westchester County is focused on, has a right to counsel movement underway. I mean, we have an Office of Housing Counsel that is pursuing the right to counsel that was enacted a year and a half ago or so. I could be losing track of time in my old age, but I know New York State has a significant movement that WRO is a part of to implement right to counsel across, and it's sort of.
It was our bill, no longer, but that was our bill for
Okay.
a while.
Nice. Very good.
Very nice, Zach. Thank you. And of course, the issue is that housing courts, the outcomes in housing courts dramatically disfavor tenants, in particular those without lawyers. So there's a systemic failure there.
I was a tenant-sided lawyer for a decade, back in 2000s, and actually more 15 years. So yes, well aware of that.
Okay, well, we've reached the end of our program, so I wanted to open it up to any of the folks on the panel. If there's anything else you want to touch upon that we didn't get to, or that I skipped over by mistake, or anything like that, we've got a few minutes if you want.
I just wanted to add one thing from my realtor friends that are on the presentation today. One of the things that Brent mentioned, which is really helpful for a realtor to be able to use when they're speaking to a landlord, is the fact that if they want to choose to discriminate against somebody who does have, who is a voucher holder, then that is the same as discriminating against any other protected class. And I think that statement really brings home to somebody what this actually means.
Yep.
Thank you, Carole. Yeah.
And I said it before, I'll say it again, we're kind of legislating the next wave of this, right? And if you want to weigh in, we love to work with stakeholders. My email is my last name, zeliff@nysenate.gov. You can find all of our stuff online. Feel free to reach out. Always happy to have those conversations and have that feedback as we're sort of crafting this legislation. So.
Yeah. And Carole, to your point, I think to add to that is, it's an immoral act to discriminate. You will get caught, as I showed you some of the, and not when you get caught, it will be painful because there are, penalties. There's lots of, you're going to lose money on it. So just don't do that. And you can also tell them that administrative burden is not an excuse. So if they say, well, Section 8, I hate it. It's really hard. I have to fill out those forms. That's not an excuse under law. Lots of courts have said you can't do that. And so like, that's the way I think you can go at it, is like, look, it's just like discriminating against somebody else. The AG and other WRO and other people are testing, you're going to get caught. And so let's not do it. And, I know it's difficult. I can help you, hopefully the next presentation will help you guide your landlords on how to navigate the systems, which I will confess are not always easy. So, yeah.
Definitely not perfect.
Exactly.
And maybe that's where we need to do more work. Is they're never going to be perfect. Nothing in life is, but they could be better. And
Agreed.
Yeah. All right. Well, on that note, we will hope we'll see you all on May 9th at 11 a.m. Again, you can register at HGAR's website or at WRO's website, wroinc.org. And we'll talk a lot more about Section 8 programs then with some folks who know how the programs run better than any of us. So I want to thank HGAR again for co-hosting this with WRO, and then most of all, I want to thank the panelists for joining, Zach, Brent, and Carole, for lending your expertise and being so thoughtful on the topic. Appreciate everything that you guys do.
Thank you.
Thanks,
Ready?
everyone.
Thank you, everybody. Really appreciate it.
Thank you all for joining.